Great. Good afternoon to all of you, and we are moving ahead with the next panel discussion. And we are honored to have legendaries, on the panel. Considering the time, I'm straight away going to the discussion, which we intend to have. I think since yesterday we have been discussing about the international taxation reforms, which possibly has taken place in the last 5 years or so, or last 10 years, and possibly few more things which may get implemented. I also heard something is going in the fridge, and that fridge theory, which is now quite popular. But for a consultant, there is always a optimistic thing that something will new come up, and then there will be some more new challenges to all of us. So what we intend to cover today is the dynamics of treaty interpretations and the treaty entitlement. Maybe just to introduce the topic, I think we are always trying to discuss whether a particular judgment is right or a wrong judgment, and I'll not get to any particular judgment at the moment, but suffice to say that very recently I think the two judgments coming from the Supreme Court tried to, I would say, summarize the tax interpretation rules in a safari judgment. I think it's a very nice, I would say, 12 commandments which have been given, how to interpret a taxation provision. When I really look at those taxation provision, I think a point really comes to our mind as to if we wish to interpret any particular treaty provision, whether the same and similar rules would apply to that, or they have to be applied with some changes to those strict rules which have been summarized by the Honorable Supreme Court. When I started studying, possibly I think we always definitely used to refer to the OECD and the UN model commentary, or the Azadi Bachao was one of the fundamental judgment at that point of time. But really a summary, if I wanted to look at some summary, I think the gentleman sitting right to me, I think almost 2 decades back, came up with 5 to 6 pointers as to how one should really look at the DTAA, the good old days of 2005. Pramod sir, if I recollect correctly, in a Boston Consulting and an Hindalco judgment, where he of course tried to give you some kind of a hint as to how to look at the treaty, how it can be interpreted, the context and everything. But I think suffice to say, today when we are really trying to look at some international reforms taking place, the fundamental question which really comes to our mind as to what could be the rules of interpretation as far as the taxation statute, as far as tax treaties, are they generally same, similar? Do we have a literal interpretation? Do we have a strict interpretation? Do we have a purposive interpretation? To what extent the tribunal members and the judges can really think about a particular provision and go back to its purpose? I think some fundamental discussion has to take place, because I think the only constant possibly could be for all of us is to, once we understand those rules, there can be subsequent amendments, or the new treaty provisions can come up. Pillar 1 can come up, which can throw us completely in a different gear. Pillar 2 has its own problems. So I think we try to understand the rules of interpretation of tax as well as tax treaty. And let me start with Pramod Kumar sir. How do you see it? I think you have been delivering judgment for almost more than 2 decades. Pramod Kumar sir, when you actually retired, I think on Tax Sutra or someone really reported, one of your colleague really wrote, in 2022, Pramod Kumar sir retired, which is a big problem as far as international taxation was concerned. And he compared that your retirement equal to Roger Federer also retired in 2022. So it was such kind of a sad moment for a tennis player and a taxation player. But over to you, sir. How do you see it?
Don't take those words too seriously. Like all brides are beautiful, all dead men are noble, all those who retire are great souls. So these are the kind words said. But thank you so much for kind words, and also for reminding me about the decision which I wrote almost 20 years ago. I think it was on 1st March 2005 that I wrote Hindalco judgment. And the backdrop of that judgment was Azadi Bachao. 2003 Azadi Bachao came, and Azadi Bachao judgment for the first time admitted that there is a line of demarcation between how the tax treaties are to be interpreted and how the tax laws are to be interpreted. In the judgment, their lordships referred to John Gladden's case from Canadian Federal Court and very extensively quoted from them. One thing which was quite clear, and I still remember that sentence which was mentioned there, that the way the treaty is to be interpreted, the key is it has to be liberal vis-a-vis the intentions of the parties. It is not only to be liberal. When you say liberal, it is not, it's immaterial whether it's in favor of the taxpayer or against the taxpayer. What is the really key factor, one single factor which dominates that thought process is that what is the true intention of the treaty which needs to be implemented. And there was also nothing new. If you see what Lord Denning said and other judges in England, there were constant number of cases from Golding, in the case of Justice Harman, in the case of Union, Texas. The underlying principle was that you cannot look at the treaty the way you look at law, which is a unilateral thing, it's a bilateral thing. And then the diplomats are not known to be the best people to have that kind of precision and accuracy. So that leeway was to be given. And Lord Denning also started by saying that you don't have to look at the words employed in such meticulous details. But the problem is that to interpret a treaty, you have to understand the broad scheme of the treaty. You have to understand the bigger picture. And I think it's that bigger picture which is the key. So rather than building a narrative in support of a proposition based on those narrow confines of the words and the expressions used, the real determinative factor is what is the scheme of the treaty? Why do you have this provision in place? What's the backdrop of it? Those things would really matter. Then you talk, undoubtedly the principles are different, but then whether you interpret a treaty or you interpret an agreement, which inherently a tax treaty is, broad principles remain the same. Every legal document, every interpretation, except for that strictness of the provision on the literal interpretation must go. So that's the scheme so far as you look at the broad question. Then you mentioned about whether there can be an international consensus on those principles. I would think that's something very difficult because that judicial sovereignty, everyone wants to have that independence. You don't want to feel constrained by too many principles when you take those calls. And judges say different things and they do things differently. Everything that they say about the principle of interpretation is not exactly what is reflected in their judgments. When you discern the principles from those judgments, you will find things going in a different direction. The reason is this: no single principle of interpretation of treaties, even if you identify those, as I tried to do 20 years ago, can be the conclusive factor. You have to look at the highest common factor in all those principles. And sometimes these principles are very vague. For example, you look at 31.1. 31.1 talks about things which you do anyway. Everyone looks at the intended purpose. You look at the plain meaning of the words. But what is so different in it? So that vagueness, that vague thing that's being amenable to different meanings, those things are to be curtailed down. Now, the most important factor, as I said, would be what is the contextual requirement of this. And then Vienna Convention, we generally talk about, you mentioned in your note, which you circulated about Article 26, Article 31, 32, 33. Now look at Article 26, for example. Article 26 requires you to perform a treaty in good faith. What is a judge going to interpret? How a judge is going to use this principle of interpretation? In one of the cases which I wrote a year before my retirement, that was case of Reliance Jio, where the question before us was, we have two possible ways of looking at a provision. We have two possible ways of looking at a term. You look at a static or you look at ambulatory. The government had made a change in the meaning of that term, which would seem probably that defeats the purpose of the treaty, that defeats the common intent at that point of time. The question before the tribunal was, if you look at a static, probably it cannot be treated as, it can be treated as a performance in good faith, but if you look at ambulatory meaning, which is what the High Court had not approved in some other case, in Siemens' case, really, then you think it is not a performance or in good faith by the government, and therefore instead of choosing option A, you choose B, because that's in consonance with Article 26. Now, when you think of the principles of interpretation, can someone say that it is decided on the basis of Article 26 alone? Answer is no. So these are the various broad principles for you to bear in mind, and bearing those broad principles in mind, it's an intuitive process. You go to this, you look at different options, and then you choose an option which is more in harmony with as many number of principles as possible. That's how it really works. For the tribunal members and the judges, the biggest challenge is that the lawyers, by their compulsions, by their commitments to the cause of clients, and for a variety of reasons, they are not there to teach the judges. They are there to build a narrative in support of a proposition. So sometimes, I'm not saying it always comes in the way of education of judges, but sometimes a narrative being built to support a proposition does conflict with the right idea about what the bigger picture is. And sometimes you get swayed by this. On occasions, you work harder and try to understand bigger picture, but it's very easy to talk about bigger picture in this conference room. I can tell you from my experience of 22 and a half years on the bench, when you actually try to understand bigger picture on the bench, whether you are in tribunal or you are in a court or wherever you are, it's a very challenging process. There's so much of work involved, and there are occasions when you are also. That is the process where I think biggest challenge for my colleagues in the tribunal was, and my distinguished, officers of the, distinguished judges of the higher courts, is to get a good idea about that bigger picture. And that's where judges need everyone's help. And the academicians like this, and then eminent people like, some of, you have Dhruv here, who's an eminent teacher or somebody who was teaching international tax all along, and suddenly you're in the courtroom. I think that's where you have to play a very, very critical role to make them understand that bigger picture. And that's where the knowledge of the lawyers also helps a lot in the judicial process.
Thank you, sir. I think before I, ask Shekhar sir to give his view, do you also follow the principle of common interpretation, sir? Generally, whenever you are trying to deal with this international tax principles.
See, if you are saying principle of common interpretation means that all of us agree on an interpretation. That's very difficult thing. Lord Denning, once again, in Corocraft's case, he said so. In Corocraft, he actually mentioned that we should have a common interpretation, judicial approach. But then we also saw how in the case of, what was the case? Nestle case before Delhi High Court. In the name of the common judicial interpretation, our High Court was swayed to accept interpretation by the tax administration of a capital exporting country to be an acceptable interpretation to a capital importing country like India. So the common interpretation, while people talk about it, in one of my judgments also, Amarchand Mangaldas, where we were dealing with the Indo-Japanese treaty, in that particular case, the tribunal accepted the interpretation given by the Japanese establishment, although that was a borderline case. I would not really think that it was a case which could have been admitted that way. But on this principle, on the Corocraft principle, it was accepted because your treaty partner has done it. Again, as far as possible, as far as treaty partner jurisdictions are concerned, an effort should always be to find a common ground. But then on a broader level, and particularly that even the courts get swayed by the value system of those jurisdictions. I mean, we can't live in denial about the fact that our perceptions about the treaty provisions also differ from kind of jurisdiction to kind of jurisdiction. If you are a capital exporting country and you are a capital importing country, sometimes your national interests do, at a very subliminal level, affect your perceptions. And we saw that, for example, happening in the case of, again, coming back to Nestle, how the clarification from the Swiss tax administration came. They said, if they accept it, then we'll also follow the path. I mean, what kind of understanding is this when it's conditional? So I would think it's an uphill task for the judges to find a common ground in all the jurisdictions, but nevertheless, it's a goal which people say they work for.
Okay, fine. Shekhar sir, I think you have been in consulting now for a substantial period of time, including you have written good commentary on the international tax. How do you see this, principles and interpretation really, playing an important role for consulting perspective?
Thank you, Sachin. And before I go on to answer, I just wanted to do two things. Number one, this is my normal practice. I dedicate whatever the knowledge that I have and whatever I do, dedicate to my living God and Guru of Kanchi Shankaracharya. And number two, I thank Arun for consecutively nominating me for the last 7 years. Ever since he started his Track Sutra on Conclave, I am one of the permanent fixtures for Arun, and I hope he continues in future also. I don't know where is Arun. But having said that, taking cue from Mr. Pramod Kumar, because I appeared before him, though one or two judgments I disagree with him, which I don't want to make it as a point of view. But coming back to the point of interpretation, Sachin, let me take 2 or 3 steps and then probably I'll come to the point. Number one, somewhere there's oft-repeated comment, this Vienna Convention, good faith and all. We all know that India is not a signatory to Vienna Convention of treaties, but in Ramjat Malani case or before Ramjat Malani case in state of Bihar versus Pratap Singh, Supreme Court made a point, much before Ramjat Malani case, Supreme Court made a point that when you are interpreting a treaty, you should consider all the international covenants and all international agreements while interpreting the treaty. Same thing was said by Supreme Court in Ramjat Malani case. Now, when we talk about a Vienna Convention, because that is always, I believe, that's a base document for interpretation of treaties. Forget about 31.1, 31.2, 31.3 and all that stuff and all the maxims. The first thing is that the treaty should be interpreted in a good faith. Because two private parties enter into an agreement, the treaty should be interpreted in a good faith. That's a fundamental rule, is good faith. The second one is that the meaning should be an ordinary meaning for the, as given in the agreement. You cannot give a special meaning. You cannot give a special meaning to the agreement because as Pramod Kumar sir mentioned in one of the judgments, and is also maker, the treaty guy, people who negotiate the treaty are not the lawyers, they are typical the diplomats and foreign, and they have their own reasons. For example, if you look at it, I give an example of service fee and fees for technical services. If you look at the service fee and the fees for technical, India is the only country that has got an exclusion of service fee other than article fees for technical services because India believes the right to taxes service income arising out of services, either as FTS or a service fee. So when the treaty negotiation happens, every country has got a way of looking at it. Similarly, in subsequent treaties, of course, I do not know whether anybody buys software from Kazakhstan and Tajikistan of the countries. If you look at that India's treaty with Kazakhstan, Tajikistan and Malaysia, they said including computer software. So every country negotiates the treaty for its own purposes. So therefore, the treaty should be interpreted given an ordinary meaning, unless the context requires a special meaning. Therefore, I cannot bucket the interpretation of treaty only a literal interpretation. As Pramod Kumar said, Azadi Bacholan case, it says that, which I agree with the judgment, if the interpretation, literal interpretation of the treaty leads to an absurd results, then you cannot do a literal interpretation, then you go for a purposive interpretation. And that's what followed by AP High Court in Sanovi, when Article 12.3, when they talks about alienation, alienation is not defined in the domestic tax law. And your Article 3.2 is that the special meaning, if I'm giving a special meaning, then I should have a solid reason for giving a special meaning. For example, which we discussed in the lunch also, Article 12.3a, for example, in the fees for taking, you buy a machine, you give a training. Mission is not taxable. The logic is that the training fee also should not be taxable. But US treaty and UK treaty has got that fees for service are inextricably linked to the sale of property. So to that extent, it doesn't become a taxable. So once again, it's not a literal interpretation, it's a purposive interpretation. Therefore, when you're doing a treaty interpretation, you need to go through all this stuff. And more important, that's my understanding of the treaty law. What I normally called the Australian principle, SWORD was a shield theory. A treaty cannot impose an obligation which is not examined or which is not in the domestic tax law. Treaty cannot impose more obligation than what is there in the domestic tax law. So therefore, if I put it together, I would like to take a view, good faith, literal interpretation, but if the literal interpretation leads to absurd results, then you go for purposive interpretation leading to ambulatory interpretation, and ordinary meaning. If ordinary meaning gives absurd results, go for a special meaning. That's the way I would like to bucket it, Sachin.
Thank you.
Just one small point I would add. when you talked about you don't agree with my judgments, I'm reminded of, no. Some judgment, no, doesn't matter. I was reminded of a book which is freely available on the internet. It is called The Nature of Judicial Process, written by Cardozo. And Cardozo has said that I don't know why people have such a great faith in dicta. Every time I look back at my own judgment, I don't find myself in agreement with the same.
No, I'll also tell you which judgment. Probably we can discuss offline. That's in your Bombay tribunal about where there's an Indian car manufacturer went for an ad in Dubai, and you said that business connection should be extended outside India. I have no idea what made you to say that, but that's a judgment which I don't agree, which I also wrote in my book, but I'll talk to you later.
If I could ever sit in a time machine, I will do something to this judgment. I tell you something very funny. Interestingly, the judgment is dated 19th of March. Yes. And the significance of 19th of March is that was the day when the COVID shutdown started. I was leaving office and we were almost in a hurry to clear as many files as we could. And I was more on the point of explaining the handicaps of the business connection model which you developed in the brick and mortar days. But then, single marks are not the only thing which intoxicate the other things also.
Sir, nowadays even the Supreme Court is going with the review and the curative one, so you can certainly think about it. But Dali, but I think you come from extensive research background, be it at IBFD level or an Orbitex currently. How do you see this? The interpretation rules are getting practically implemented across the jurisdiction. Anything you wish to share with all of us?
Oh, it's on. Can you hear me? Yes, all right, great. Yeah, thank you. I mean, I do agree on the principles as they were just mentioned. Of course, you have to look at the intent of the parties. It's not like domestic law in the sense that you have like parliamentary proceedings, and that way you can actually derive the intent of the parties. Historically, there was a situation in France where basically the courts had to ask the Ministry of Foreign Affairs what the intention was, right? Which is a little bit crazy because the government is a party to the proceedings, right? But because actually the Ministry of Foreign Affairs does the negotiations, it's assumed that the ministry would know what the intention of the parties is. But that has been abandoned a long time ago in my very early career in tax, right? In Europe, we have also a complication coming from EU law, which sheds a little bit of shadow on this whole thing, and from an increasing amount of soft laws, right, which add complication to the interpretation. But what I see happening is, of course, you have to weigh all these, what Mr. Pramod was calling the common denominator. You look for the most common denominator in all of this. But what I would think myself is that what should be given more weight is actually, when there is doubt, give the benefit of doubt to the taxpayer in interpreting this. We had a case recently in Holland, which sort of exemplifies what I'm saying. This is a case about the application of the treaty between the Netherlands and Brazil on the notional interest deduction. So Brazil introduced a notional interest deduction, and the issue was, what is it for treaty purposes? Is it interest or dividends? And the difference does make, the characterization here does make a difference, in fact, right? The notional interest deduction was introduced actually after the conclusion of the treaty, right? And so the treaty does not even talk about it. For Brazilian domestic law purposes, it's treated as interest, right? And then the competent authorities of the Netherlands and Brazil, because there was like a lot of confusion about it. What is it? Is it interest, dividends? Obviously, the recipient is claiming that it is a dividend, because that way, Brazil does not have a withholding tax on dividends under its domestic laws, so there is no withholding tax in contrast to interest. And in the Netherlands, it would benefit from the participation exemption, right? So the competent authorities got together and issued something together, saying this is interest for the treaty, right? And you would think that is the intent of the parties, right? I mean, they are the two competent authorities. They negotiated the treaty. The thing is that the treaty was negotiated before the introduction of the national introduction. And the judge said, no, you cannot do that. You can't do that. This interpretation comes after the conclusion of the treaty, and it is burdensome to the taxpayer, and you cannot apply it to the taxpayer like this, so you give the benefit to the taxpayer, and it is a dividend. Of course, it is now in appeal, so we don't know how it's going to happen, but it gives a little bit an idea about the judiciary thinking, at least in Northern European countries, I think, where in unclear situations, you follow all these principles, what Mr. Pramod mentioned, etc. In case of doubt, you give the benefit of doubt to the taxpayer. That's getting a little bit lost nowadays because of a perception of abuse, right? Which doesn't come from a vacuum. It comes from actual abuse happening at great scales, and sometimes facilitated by countries, right? And that pushes the judiciary in many cases to actually presume some kind of suspicion, at least, right? Which influences their decision.
Thanks. I think, good to know, Dali, that, not only India, we have a disputes, even in European countries, within the countries also you have a dispute. Good to know at least about that. Let me come to Anjali. Anjali, I think you have heard all the three panelists. Of course, during the practice, when you are actually implementing it, we need to, interpret the DTAAs and, take the rightful meaning. So how do you see it, when you are actually implementing a particular transaction or, trying to interpret a particular term? Do you see any particular trend in the judiciary which is coming off, or, how do you summarize, the way they have tried to, give us some fundamental understanding of the interpretation of treaties?
Hello, am I audible? Yeah, good evening everyone. Thank you, Sachin. So, much has been already said about, how to interpret the treaty, and I agree with it. But how I look at it is that treaty is ultimately an agreement between two nations. So interpretation of contract is what is more important here than interpretation of statutes. And contract, again, has both literal, you have to go to the literal language of the contract, and you go to the purpose or the good faith or any other extraneous aids only where there is an absurdity in the language. That is how I look at it. But to your question about, applying it in our transactions, one has to be mindful about, how the judiciary is looking at it, what is the current scene in the country, what are the chances of success. So what I really look here is that, since India has become an economic superpower, it has been taking more and more unilateral stands with respect to interpretation of treaties. Lots and lots of retrospective amendments, trying to bring in unilateral meaning and definitions to words which are being used to the treaty, be it liable to tax, be it less favorable. So it is about marrying the domestic provisions with the treaty provisions, which I think India is really facing today. And most of the controversies, if you will see, be it Sanofi, sir referred to, or the engineering analysis, and all other various cases, the GAR versus SAR, the GAR now is supposed to be, overriding the treaty provisions. So from a practitioner's point of view, I think we look at it from that angle more. And somewhere I feel that, the way the decisions are being given right now, the technical part of the entire interpretation is losing its prevalence, or, the judges are more colored by the merits of the case or the substance, because right now, the language of the world is substance over form. So somewhere I take the example of the recent Telangana High Court decision, GAR versus SAR. I'm not sure, of course, the technical argument also have some arguments, I would say, I would not go into it, but I feel that the decision is more colored by the facts of that case rather than anything else. So maybe the facts were strong, we could have had a separate decision, today in morning ASG, he told us, in so many words, so candidly, that taxpayers have to, let go of the technical arguments and really look at what is the worth. But with due respect, I have a little different aspect on that. See, under Article 265 of the Constitution, the state can levy tax or exact tax only under the authority of law. Now, authority of law is both procedural law, technical law, and the merits. So it's not just that one has to see only the merits. And how do you bring curbs and balances in the lower level? So unless the technical laws are adhered to, you never know what the tax officer will, the reopening, the Tola case, if one has to see. If there are limits, if there is a time limit, then one has to adhere to it. Otherwise, only because my facts were bad, can the judge or the tax officer come to me 10 years later? No, you were wrong then, I don't care about the technical law and therefore you have to go. So that is the kind of controversy which we are seeing. And so from the practical aspect, I completely agree, good faith and all of it. But that is what I think, we are grappling as taxpayers and as consultants.
Very well said. As far as the interpretation of the agreements, I'm going to come back to you. And I believe Arun did give a promise to the ASG that he'll come up with 10 sort of suggestion. I think you are not going to be party to that because you strongly disagree on some of the point. But suffice to, before I really want to go to Shekhar sir for the next important point. Pramod sir, I think Dali did mention one important point, whenever there is a doubt, it should go in favor of the taxpayer. Maybe I think one important point, if you can clarify, I always, get stuck with the constitutional bench judgment in Dilip Kumar, which tries to give you, if it is a charging provision, of course, it's in favor of the taxpayer, but if it is an exemption related provision, it goes in favor of the tax department. Now, trying to take some logics out of it, and when we are trying to interpret a treaty, would you apply that principle to the treaty at all?
First of all, treaty is not an exemption regime. I think there's a paradigm issue. And way back in 2008, I think, or 2007, Justice Ishwar, who was at that point of time on our tribunal, in the Income Tax Appellate Tribunal, he authored a judgment in the case of Motorola, where he laid down the theory that it's an alternate taxation regime. So one shouldn't look at treaty as a kind of exemption regime. And there's also an issue about, some people say, first look at the act. If it is taxable, then you see whether it's exempt under the treaty or not. I don't subscribe to this theory. So the question of exemption regime doesn't come into play. As far as Dilip Kumar's case is concerned, that is purely in the context of an exemption regime, and that too in case of the indirect taxes. I don't think this has any relevance so far as treaty interpretation is concerned. And remember, treaty interpretation, other point which you made about the benefit of doubt. Please forgive me for saying so, but the way I look at it is this. It's one of the crudest tests, and it's a shame to a judge when he says, no, both the interpretations are possible, therefore I take one which is in favor. How can two interpretations be possible? Either you are inside the room or you are outside the room. When you are looking at the intent of the provision, you have to look at intent, and all this discussion we had even in the case of Azadi Bachao, which is often talked about. They said liberal to the intention of the parties. Kindly read that again. It is not liberal to the taxpayer. And when you are liberal to the intention of the parties, it may so happen that you may have to do a little bit of violence to the language. There is a case from House of Lords, Axon's case. I had referred to this judgment in my Hindalco judgment. This is the judgment we were talking about. It's a 2005 tribunal decision. In that case, Justice Golding has used an expression. He has said, to implement the intention, I may have to do violence to the words of the agreement. But I will not inflict a wound deeper than necessary. And therefore, same expression used twice in a sentence, at one place he deviates from its meaning, and at the other place he takes its natural meaning. Now, if that be the course of action in interpretation and application of intent, I don't think there should be any question of ambiguity about possible alternatives. If at all you have difficulty, that difficulty is in understanding the scheme of the treaty, from which you get to the notions of what is the contextual meaning, what is the intent of and the purpose. And Article 31.1, as you were mentioning, 31.1 talks about intent and purpose and the context, but that again is defined in 31.2. So that's also a narrow meaning. And as I was saying initially, what judges do and what judges say are not necessarily the same thing. Every judicial officer in the country, whether he's in the ITAT or he's in the Commissioner Appeal or he's in the High Court or in the Supreme Court, they refer to OECD commentaries. Under which article they refer to it? Is it Article 32? That's the only situation where they refer to it. When does Article 32 come into play? When you have reached a meaning and you want to understand it to corroborate something, or there is an ambiguity. There are three conditions in which Article 32 would come into play. None of those three conditions are ever dealt with. And we jump straight on the commentaries. And then based on the commentaries, we come to conclusions. Therefore, don't be too much swayed by what judges talk about when they say on the principles and what judges end up actually doing. It is more instinctive because when you look at the OECD commentary, you have a ready-made analysis available. You have everything available. You pick up which one is right, which one is wrong, and then you add a few sentences of admiration. And this is the easiest option. So to say that you have two views which are possible and that too coming from a person holding a judicial office, I think it is not a very happy state of affairs. On a very personal note for the judge, when he hits the pillow that night, I think he'll not be comfortable.
Very well said, sir. Thank you. Maybe I think, Shekhar sir, let's move on to the next important point. I think, earlier generally I would say most of the time what we used to do as far as the treaty were concerned, try to understand, what is the meaning of FTS or a P and so on and so forth. But even currently the way the things are taking shape at a policy level, the treaty entitlement itself is being questioned at a threshold. If you really look at the domestic tax level, be it a TRC or be it a definition of liable to tax, or also at an international level now there is a consensus because of the BEPS as to, you have changed the preamble, now there is a PPT and then there is a SLOB, possibly beneficial ownership is the old concept. But what I'm trying to ask you now is, in this change scenario, and I think the title of this conclave itself is, whether the international tax reforms mission accomplished. What is the mission? And how do you really look at it today, in a sense that you have the old logics, now there is a new loaded logic which is coming our way, and now you need to interpret it and apply for the benefit of the taxpayer. Or also, if it is not necessarily applicable, then don't apply it. But looking at these new challenges, how should one really look at the treaty entitlement itself?
You need one more one-day conference to go through all these topics. But I do not know whether I'll try to answer in 7.5 minutes, which you said it for me. Jokes apart, Sachin, it's very difficult for all the countries to come on a common platform to give a framework for all these words. Let me give a smallest example. The biggest controversy in India came on Vodafone. Do you know what is the reason for Vodafone controversy? I was speaking with one of the secretaries in the Ministry of Finance. He said, Shekhar, the entire tax Vodafone is equivalent to one state budget. He was not worried about the tax law or the treaty law or anything. He was more worried about that India as a country is losing a revenue and the tax of that particular revenue can be equivalent of my one state budget. Now, when you have an economic thinking like that, and the law is not aligned to an economic thinking, therefore, as a tax officer or as an advocate, I am trying to find out the best ways to unsettle the process. Now, Anjali talked about GAR versus SAR. What is the fundamental principle of GAR, which is well established in Canada, UK, and New Zealand? What is called the choice principle. India has recognized the choice principle in the legislation as well as in the Shom Committee. What does it say? You are entitled to restructure the business in a manner which it helps you as long as there is a commercial benefit. But your entire Telangana High Court, with due respect to Telangana High Court, they have not even gone into the facts. I only hope Supreme Court reinstate the facts and look at it. And I have another similar case in Karnataka High Court where the GAR panel never looked at it, the choice principle. Now, what is the reason? Because they immediately collaborate. The tax planning is tax evasion. Now, when you have got this sort of a thinking, you cannot expect a common law or a common understanding. Third principle, you are talking about the liability tax. Liability tax, once again, the law is settled today, fortunately, in India, unless somebody, now people wanted to file the trend is that special review petition against every judgment. I only hope nobody files a special review petition against the old judgments of liability tax. Vodafone, in that word, judgment of Vodafone, the single judge gave a very good ruling. I only hope nobody goes a review petition against that. Now, the liability tax issue is settled. To my mind, it's fair, that principle. But what is important is that I was just doing an interpretation of 10.2 in a different context a couple of weeks back to one of my clients. The principle that emerged out of various purposes is that what can be excluded under chapter 3, I'm talking about chapter 3 of income tax, it's got nothing to do with the treaty, but the principle is important. What can be excluded under chapter 3 is only what can be included. What cannot be included cannot be excluded. That's a maxim. Now, if you have to apply that principle to liability tax and subject to that, the principle remains same. Fortunately, the liability tax issue is settled. I hope it gets settled. Now, the last point that you asked about, Gar and Madam talked about treaty law. That's one maxim which I used to joke with my fellow professionals in office as well as what is called man marrying twice. A person married once, first one female. The condition of the person is that you should not go for employment. You should be a housewife. The person divorced his first wife. What would be the reason? The condition between the man and the women was that the women should not go for employment. Now he is marrying once again. His expectation is that the second wife should also accept the same condition of the first wife without mentioning to the second wife. So when you are entering into treaty with two countries, and that is where the UN treaty negotiation comes. When a party is entering into a treaty with X country, and it is bringing the same terms of the X with the country Y, it is expected that the country Y will go through that manual and understand what is the party of meetings of country X. Unfortunately, Supreme Court in MFN clause, none of these principles were brought out. And I'm extremely disappointed with MFN clause. I do not know whether I would like to have a time. But these are principles at which you can restrict such.
One small point I must add. You talk about the settled law. But remember, no, there is a huge and clearly discernible change in the value system of judiciary. Think of the situation which prevailed 20 years ago. Nobody was aware about this, famous building, which, as Obama put it in his election campaign, which is either biggest building in the world or which is biggest scam in the world, which had offices of 36,000 corporations. Today, there is so much of deluge of information. People are so well informed. I can tell you that if tomorrow morning on my breakfast table, I talk about transfer pricing to my wife, or forget about it, having married to me, she probably hears these things. I talk to a child who is, let's say, 12-year-old. I talk to transfer pricing, he'll have some idea about what it is. He'll have some idea about tax havens. So you are talking about the law which was developed in that era of ignorance. Today, judges are not the same people. They read the same newspaper which we do. They go to the same internet. All these secrets are open secrets today. And judges don't write essays. You say this principle is not applicable. They write in a given situation. They write within the constraints of the information available to them. If I have to write the judgment of Green Emirates today, I don't think I'll be same man. If Justice Shri Krishna comes back and to the court and he has to write Azadi Bachao, maybe he'll have some other ideas. So remember the change in the value system, and as a consultant, we not only read what the law is, we not only read what the judicial precedents are, we also try to visualize how the law is going to evolve by the time this case is going to put to test. That you must factor for.
So, sir says, dynamic interpretation.
Ambulatory, that's what. But I think, that scares me that, if today, I think you did mention about someone should not file a review petition of that. Otherwise, the decision could be different. I think we'll have to be...
I just want to take only 1 second, a little bit digressing. Sir said...
Krishna says goodbye to
Sachin, sir said talking about a transfer pricing to his wife. I'll just give only 1 second joke. It's out of tax. I became a partner in 2004 in Deloitte. I met one global tax head of one big company. He met me third day after becoming partner. He said, Shekhar, I'll give one small tips to you how you can be successful. I tell me, sir, what is that? He said, whenever I'm going to talk about tax to my global CEO, I will talk to my wife for 2 minutes. If my wife understands it within 2 minutes, I'll be successful with my global CEO.
Good benchmark, sir.
You have
Shekhar
no
sir.
idea, Sekhar, you have given, enough work to my wife.
Shekhar sir, if I can add on that.
Yeah, please.
So on the tips part of it, our mentor, Bansi Mehta sir, he always narrates a story to us that, that some senior counselor had told him that what is your, he was asked a question, what is the mantra of your success? So he told, I analyze the case. If the facts are strong, I hammer the facts. If the law is strong, I hammer the law. So they asked, what do you do if both are not good?
Constitution.
I hammer the judge. Sorry, Pramod sir. That is what was told to me. But now I feel, as I was telling earlier, that now the SEC has no other option but to hammer just the facts. What Pramod sir was just telling.
He said, if you're sure on facts, argue on facts. If you're sure on law, argue on law. If you're neither sure on facts nor on the law, argue on the constitutional validity of the provision.
But now I feel maybe what Pramod sir was saying because of the changing dynamics. It's only facts.
No, sure. No, but I think one important point Pramod sir made, Dali, to you possibly, the info. Yeah. The,
7 minutes.
yeah. Fine. Yeah, I think then let me shift to the MFN. I think, even though we have discussed this, number of times during the 1.5 day conference, let me quickly come to you. You have a different take on MFN. We heard many, during the last couple of days, but I think what's the key thing which really bothering you that MFN judgment?
See, I think MFN judgment, I think it's been bothering, I think, almost everyone. See, much has been already said, so I'll not speak a lot on that. We already know the ramifications of the judgment. So what I really am grappling with is that in this case, the court, they upheld the stand of the government by relying on the past practice of the government. But if we see, the government has actually defaulted in, in actually implementing those past practices by not issuing notifications, by in fact, like for example, in the case of Spain, issuing a notification by prospective effect, referring to a treaty, a favorable treaty, in 1996. They said it will be applicable only from assessment year 2024-25. And in all this, who is paying, who is bearing the burden? Only the taxpayers. So is it right that, this ramification of this judgment is actually resulting in unilateral overriding of a bilateral treaty, and the result is that the taxpayers are bearing the brunt? So, I sat and started analyzing the decision, and I see three things which, I find a little difficult to digest. One is this, of course, they have referred to Article 253, read with 92, and it said that for a treaty to be a law in India, there has to be a notification. But the point is that the notification is already there.
Absolutely.
Protocol by its preamble is a part of the, integrated part of the DTAA, which has already been notified. So I don't find anywhere in the judgment where it is written that there is a need of a second notification, only by way of past practice, right? But when I come to past practice, where is the authority for this past practice coming from? From Article 31.3 of Vienna Convention. Now, as Shekhar sir was telling us that we are not signatories to Vienna Convention. So what I feel is it's just an extraneous aid. It's not a law of the country. But what the law of the country is, the treaty, which is already notified, the protocol which is notified. And there's so clearly when we read the literal interpretation, we concentrate only on the literal interpretation, and Indo-Swiss is the biggest example there, where we see the difference in the language, clear difference in the language about what is automatic MFN clause, what is not an automatic MFN clause. There has been a negotiation and then they have changed the language. And yet that aspect is totally ignored. Okay, fine, subsequent practice is of interpretation, but why would it override a literal interpretation? What is between the two? Why would subsequent interpretation, take more hold? That is where I'm grappling with. Because if you would notice, there's a recent decision of Calcutta High Court in Royal Scotland, where, Nestle SA has been referred to. And then referring to that, they have actually again reiterated that, when there is a conflict between domestic law and for international treaty, domestic law should prevail. So I'm just worried Where will this lead us to? You know, the other ramifications are of course there, which we have already know, the foreign tax credit, the implications on the past cases.
Absolutely.
So all that is there. Just one interesting further point, on the first point, that, there are two controversies here. One is about whether, the time when the member should be an OECD member. So while arguing there, ASG really argued, he relied on this interpretation rule that, you cannot make a provision redundant. One of the interpretation rules, I think Sir has also referred it to in Hindalco or ITC case, that, yeah, so you cannot render something redundant. Relying on that interpretation, he has argued that, if you allow OECD members who have, countries who have become OECD members subsequently, then in that case, you are rendering that provision redundant, because at that time, India would not have anticipated, that by giving a better tax treatment to Slovenia or to Lithuania, that, my other treaties would get impacted. They would not even, considered it, because ultimately treaty is, a bilateral agreement having economic ramifications also. So there the court agreed to it. But, on the second part of it, when they go for subsequent practice and 253, the entire MFN clause is getting redundant. And yet that principle is
So
not
I think
being applied.
definitely we have a more litigation going to be there for the MFN. And I don't know what Tax Sutra has, last time when this MFN judgment was pronounced, we had a tax conclave at
Right.
a
So
tax.
hopefully
Sachin,
right now MFN
I would
is
like
for
to come supplement on
reconsideration.
MF1.
Please,
Just 2 minutes.
Yeah, quickly, sir.
I am not worried whether the judgment is in favor of the taxpayer or the revenue. The process that it followed for the judgment is absolutely absurd, with due respect to the Supreme Court and the judge and everybody. The judgment has nowhere gone into the history of MF1 clauses. What is the meaning of MF1 clauses? The MF1 clause has multiple classifications. In fact, 60 pages is a judgment. In my book, I wrote about why the MF1 judgment is not correct for 35 pages. What are the types of MF1 clauses? There is a classic, there is an inverse, there is a hybrid. We follow classic clauses. Then, what is the meaning of protocol? There's a brilliant judgment by the UK House of Lords. The protocol is nothing but that balances between the treaty and the function of the treaty. It tells about what is the function of a protocol. Third, when protocol can be part of a treaty, why protocol cannot be part of a treaty is part of a UN treaty negotiation, which is where India is binding on that. None of these have been discussed. The entire Supreme Court went on one principle called ease, which is there in the notification. The term ease was influenced the entire judgment, and that's the reason I believe the judgment, the term ease within the notification. That phrase ease, presence of the phrase ease in the notification has influenced the judgment. Unfortunately, Supreme Court has made a basic flaw in the entire interpretation of the MFN clauses.
So,
If I may.
yeah, please. Yeah.
Thank you. So on the MFN situation, obviously I cannot make comments on Indian constitutional issues. Globally, there are two issues, right? The first issue basically is whether or not it's triggered automatically, and the second one is this OECD membership. Now, on the first one, I don't want to use really improper language, but to me, it sounds like in a wedding, in a marriage, you need a contract for the marriage and a contract for the consummation of the marriage, right? Which is a little bit bizarre in a way. Sorry if I hurt any. That's how it sounds.
It's bizarre, Dolly, but in some parts of India, there is one marriage and one gona, they call it. So, I think they picked up from the...
So it must have been.
Because those were the days people used to get married at the age of 8 and 9. So one marriage will take place, and 5 years after the marriage, there will be another
There
celebration.
comes the...
So that's a customary law, possibly, I think it is coming from. But I think
right, thank you.
we are, yeah, sorry.
On anticipation of being an OECD member, yes or no. I've discussed this actually with a friend here last night, and he did not agree with my approach. But if I think in the absurd, all right, let's take a situation, for example, where you have a tax treaty between country A and an EU country, EU member state, right? Providing for 15%, for example, withholding tax rate. suppose there is an MFN in there saying that if a lower rate is agreed with another EU member state, then that lower rate applies. Suppose now that country X, I said, passes treaty with the UK, being an EU member state, providing for 5%. Treaty is triggered, right? Yes. Okay. Now the UK leaves the EU. What do? We go back and we say, yeah, it was also not anticipated that the UK would leave the EU, right? Dhruv, I think, told me it is like a false equivalence principle, but I still think that basically, as a treaty negotiator, you know that the OECD is not a block of concrete that does not change with time. Of course, nobody anticipated that some of the members, some countries would become members, but it's not excluded either, right? And so, if you want to exclude something in a treaty, first of all, nobody forced you to conclude a treaty. It's a choice, right? The US have probably one of their biggest allies and biggest economic partners, Saudi Arabia. They don't have a treaty with them and they don't care, right? Nobody forced you to actually conclude that treaty. If you concluded the treaty and you have concerns, express them in the treaty itself, right? So, say for example, here, what was it? Add just one word, and which is an OECD member country at the time of conclusion of the treaty.
Absolutely.
That's it, and you're covered. I get back to the benefit of the taxpayer, Mr. Pramod, if I may. In this case, they did not add that language, right? When they could have. Then, for me, I would give the benefit of the doubt to the taxpayer.
I thought I would not. I promised myself that I'll not talk about MFN judgment.
But you can't resist.
I can't resist. Two things. One, the point you made, that's a parity group point. The question to my mind is, what was the parity group which was sought to be introduced at the point of time when treaties were entered into? And once again, the test of intentions would come into play. I wouldn't go beyond that. Second thing, you talked about it's very easy to say today that this judgment is wrong, we can criticize it for hours. But what are the lessons we are taking away from this? That's the most important part. And one lesson which I think is an important lesson for any tax administration. It's very easy to say that no, the Supreme Court should not have taken into account 3132. They should not have looked at the past practice. But then it's a reality that after the MFN clause was triggered, there were negotiations between the contracting states with respect to issuance of notification. So now, you can't be more loyal to the king than king himself. King is, the person who is the affected party, they are getting into negotiations. And when we are looking at the intent of parties, a short while ago we discussed how intent is critical. That's what Supreme Court also pointed out. In Gladden's case, it is pointed out, umpteen UK cases, and from all over the world. Now, if today France enters into negotiations with India, with respect to issuance of a notification to implement an automatic MFN clause, what phase do they have to come back and say, no, it's not required. You still go ahead, you ignore our practices. How do you ignore these practices? When I think from the revenues point of view, and one of the joy of, being an independent person and being a lawyer is, you look from all possible points of view. You have your loyalty to none, probably only to your billing clerk, if at all you have it from somebody. So from revenues perspective, I can't answer this question. When I meet these officers in private, we discuss this, and when a very senior person pointed out to me, he said, Pramod, everything is fine. But tell me what the government of France was doing when they were entering into these negotiations. And once they were doing it, how can you say that, that 3132 cannot be invoked? So some lesson is there for the tax administrations also, which must not be invoked.
I think the conduct.
I'll just add one word. So in the meanwhile, what's happening is that the other country would consider, in this case, that the MFN clause has been triggered and would not give a credit.
Yeah, absolutely. That's the double dip.
And
Double
remember when this case came up before me for the first time, and that was good 24 years ago. He wrote 35 pages on that, and I think in 35 minutes my order was over. The entire hearing, the entire hearing lasted for at the most 15 minutes. There was nothing because we said open and shut situation. But then mercifully, I was not aware about what government of France was doing with the CBDT officers after the automatic clause was invoked.
No, I think to conclude this, maybe in 30 seconds, sir, do you really feel? Oh, okay, so 15 seconds. Do you really feel that we are ready for the future? Whatever is implemented, are we ready for? Don't look at that, sir. Whatever is come to your mind. 10 seconds now.
1 second, no.
What do you feel, sir? Yes or no? Are we ready?
International tax accomplished, mission accomplished.
Are we ready for what?
To really face the challenges coming out of the new implementation.
We are absolutely certain that lawyers, chartered accountants, consultants will remain busy. They'll have plenty of things to answer, and that's what you are all bothered about.
5 seconds.
No.
So the answer, of course, this is the last technical session, and I can say after listening to the 2 days, the answer is a clear no. I mean, none of them can say that. We have learned BEPS 1 is dead, guys.
What do you want?
A big hand for the panel, please. Big hand. And this is the last panel. We have one more session. Speaking, what's the topic group? Can you? Could you talk about it? What are you going to talk?
Come on.
Very interesting topic.
The title is